This is your Chapter 3, Section 1 presentation, and this chapter covers the concept of federalism. The essential question we're going to be looking at in Section 1 is what is the basic structure of the federal system, and how does the Constitution allocate power in that system? So what is the structure, and how is power allocated? On April 24, 2010, Arizona Governor Jan Brewer signed an immigration law that authorized local police to stop and question suspected illegal immigrants and then required that those under suspicion produce evidence of citizenship before being released. Immediately, groups started expressing outrage at the actions of the governor of Arizona. The Mexican American Legal Defense and Education Fund said that the law would create fear, distrust, crime, litigation, and have nationwide implications. President Barack Obama, despite the fact that presidents are pretty much always reluctant to speak on state laws for fear that such intervention compromises the federal system, noted that the bill's provisions undermined basic notions of fairness that we cherish as Americans, and as well as the trust between police and our communities that is so crucial to keeping us safe. Supporters of the bill argued that the state government was within its rights to enact legislation because while the national government has supreme authority over foreign affairs, the 10th Amendment empowers states to act when the federal government has not. And their argument is basically that on immigration, the federal government had failed to act. In fact, they pointed to the fact that that 48 states have passed over 200 laws involving the topic of immigration since 2007, as the federal government languished to come up with a real policy or legal framework for modern immigration. They also argue that state government is better equipped than national government to handle the problem because Arizona in particular has more practical experience with the issue of immigration than Washington, D.C. And suggested that state legislatures, because of that experience, can craft solutions and can act as laboratories of democracy. And the solutions will both meet the needs of the state and, if successful, can later be adopted by the national government. The law, not surprisingly, was immediately challenged in the federal court system by the federal government itself. In Arizona versus the United States, the 2012 Supreme Court case revolving around this law, the Supreme Court ruled that 3 sections of the law are unconstitutional. Number 1, the requirement of legal immigrants to carry registration documents at all times. The part of the law that allowed state police to arrest any individual for suspicion of being an illegal immigrant. And the part of the law that made it a crime for an illegal immigrant to search for a job or to hold one in the state. They did uphold the right of the police to investigate the status of an individual if they had reasonable suspicion that they were an illegal alien. And of course, racial profiling is not reasonable suspicion. The basis of the court's decision was that federal law preempted those portions of state law that were ruled unconstitutional. So the challenge when we start to look at this idea of federalism is to preserve state independence and power while establishing a national, effective national government. We know that the powers are divided between the state and the national government, and that even on the national level, it's divided among the executive, the legislative, and judicial. This sort of 2-tiered vertical structure is what Madison in Federalist 51 referred to as one layer of security, and then the division horizontally between the 3 branches is a second level of security, what he called double security of the people's rights. Today, there are something like 89,000 different government units in the United States. The Constitution lays out the duties, obligations, and powers of the national and state government. And the relationship between the units has been reshaped by crisis, historical evolution, and public expectations and judicial interpretation throughout our history. Issues involving the distribution of power impact you on a daily basis. Some areas are national, some are state, others are state only, and others are national only. So, how power is divided impacts your life on a daily basis. Who is involved in determining the speed limit? Who's involved in determining uh, criminal law, tax law? Who's involved in determining daylight savings times, etc.? The United States is the first country to adopt a federal system. A federal system is a system of government where the national government and state government share power and derive all authority from the people. It was designed to solve the problems and experience under the Articles of a Confederation. The Articles government was a confederation, as we've talked about before. The type of government where a national government derives its power from the states, which acted as a loose league of friendship or a loose league of independent states. It was a weak government unable to respond to the challenges of the nation. For instance, Shays' Rebellion. Great Britain, on the other hand, had a unitary system. This was a system of government where local and regional governments derived their authority from a strong national government. The framers considered the English kings tyrants and therefore feared this form of government. They feared centralizing the power in one government or institution. And so they made both the state and federal governments accountable to the people at large. That's where their power come from. And while they were shaped by, while they shared some powers, for instance, taxing, each government was supreme in certain spheres. Other systems have adopted a similar system to the United States since we adopted the federal system, including places like Canada. And so you can see here how this sort of works. In a federal system, the federal government and the states derive their authority from the people. Okay, so you can see the power going down to the national government and up to the states, all from the people. In a unitary system, what Great Britain had, local and regional governments derived their authority from the central government. So the power went to the national government, who then distributed it to the local and regional governments. In a confederation, the power went from the people to the states and then to the national government. They're all different, but what's unique about the federal system is that the power on both a local and state level, as well as the national level, is derived from the states, rather than the states being one removed from at least one form of government. Under our Constitution, the national government has a number of powers. Their main exclusive powers that they only hold, are enumerated powers. Article 1, Section 8, for instance, are enumerated in Article 1, Section 8. For instance, coining money, conducting foreign relations, providing for an army and navy, and declaring war. Article 1, Section 8 also includes the necessary and proper clause, or the elastic clause. Powers derived from this clause are known as implied powers. The federal government's right to collect duties and excises was also set out in the Constitution. The framers were seeking to avoid the financial problems of the Articles government. This allowed the new government the exclusive power to collect tariffs as a way of asserting their power and eliminating trade wars between states. The states also have powers under the Constitution, but the states' powers are broader because the states, at the signing of the Constitution, at the ratification of the Constitution, had all the power. And so the underlying assumption was that they maintained that power. With the exception of the powers that they gave to the Constitution, that they gave to the national government when ratifying, they hypothetically retained all other powers. Even without the 10th Amendment that we'll talk about in a second, it would have been assumed, and it was assumed by many, that the states still retained any power that hadn't been given to the federal government by the Constitution. Some state powers, however, are in the Constitution. For instance, Article 1 says that time, places, and manner for holding elections for senators and representatives lies with the state. Article 2, each state has the power to appoint electors to vote in the Electoral College for the president. And Article 4 says that each state is required to have a Republican form of government. The 10th Amendment describes state power in more detail. It says that powers not delegated to the national governments or specifically withheld from the states stay with the states. So that's the final part of the Bill of Rights, and it really does define the basic principle of American federalism. Reserve powers or police powers are those powers that are referred to in the 10th Amendment, the ones not delegated or withheld from. The reserved powers are the powers that the state has, and they lie at the foundation of the state's right to legislate for public health and welfare of its citizenship. Some controversial expressions of police powers, including abortion laws and the death penalty, which can be different from state to state, as well as criminal law and a number of other powers that have been reserved to the states. There are also concurrent powers. These are powers that both the state and the national government share, overlapping powers, if you will. Some big examples: the power to tax, the right to borrow money, to establish courts, to charter banks, and to spend money for the general welfare, tax being the biggest of those. And so here you can pause and take a look at the breakdown of national powers versus concurrent shared powers versus state powers. There are also powers denied under the Constitution. Article 1 denies powers to the national government, including barring favoring one state over another as commerce is regulated, or laying duties on items exported from one state but not another. They also can't grant titles of nobility, which is why we don't have an aristocracy technically in the United States. And it also says that employees of the government may not accept salaries from or gifts from foreign heads of state. The states and the national governments are both denied the authority to take arbitrary action affecting constitutional rights and liberties. For instance, they can't pass bills of attainder, a law declaring an act illegal without judicial trial, sometimes targeting specific person or groups of people. They can't pass ex post facto laws. They can't pass laws that make an act punishable as a crime, even if the action was legal at the time it was committed. States are also denied rights. The states are denied the right to coin money, to regulate commerce between the states and between states and foreign governments, as well as to raise their own military other than the National Guard. Interstate relations, a really important part of federalism, is also covered under the Constitution. The Constitution provides a mechanism for resolving interstate disputes, other than war, like we saw with the Articles, or other retaliatory taxes, etc., to facilitate relations amongst the states. Article 3 says that all disputes between states are resolved by the Supreme Court. They have original jurisdiction, meaning that if New Jersey sues New York, it goes directly to the Supreme Court. It doesn't have to go through the rest of the federal court system. The full faith and credit clause of Article 4 says that judicial decrees and contracts made in one state will be binding and enforceable in any other state. This facilitates trade and commercial relationships. The Privileges and Immunities Clause of Article 4 of the Constitution guarantees that citizens of each state are afforded the same rights as citizens of all other states. Jumping back to full faith and credit, you saw this be controversial as same-sex marriage became legal in one state, and then another state, and then another state, but not the fifth state, the fourth state. And so if somebody moved from state A to state B and it was legal in state A, but not state B, they were suing to say that state B was violating the full faith and credit clause because they weren't recognizing the same-sex marriage. It was a very complicated issue until Obergefell ruled that same-sex marriage, that it was unconstitutional to deny two people of the same sex the right to marry. The extradition clause, jumping down, is also part of Article 4, and it requires that states extradite or return criminals to the states where they've been convicted or are to stand trial. The local government under the Constitution, basically under the Constitution, local governments have no independent standing. In other words, they don't exist unless the state governments establish or charter them. And states do that and have done that in every single state. There are tons of local governments, and they're basically established to execute the duties of the state government on a smaller scale. I've also included on Google Classroom in the Chapter 4 topic, the presentation for local government. We don't cover that in AP US history or in AP US government anymore. But if you're interested in learning more about it, and it does give you kind of a clearer idea on federalism, you can take a look at that. But now that you've gone through this presentation, I want you to go back to Google Classroom and complete the essential question comprehension check for essential question number 14. What is the basic structure of the federal system, and how does the Constitution allocate power in that system?